So I think we're going to get started with the second panel. My name is Karina Lubell, and I'm a senior correspondent at the Capitol Forum. And so the last panel was about the alleged economic harm. We're going to be talking about the alleged economic benefits. So just to introduce you to our panelists, next to me is Harold Feld, who's a senior vice president of public knowledge, where he advocates for the public interest in media and telecom, among other industries. Then we have Mandy Reeves, who's global co-chair of Latham & Watkins Antitrust Competition Practice and regularly counsels clients on merger investigations before both the FTC and the Department of Justice. And at the end, we have Peter Gray, who spent more than 2 decades as a trial attorney at the Antitrust Division, where he focused on telecom markets, including the Comcast, NBCU, and Comcast Time Warner cable deals. So economic benefits play an important role in deal rationale in any merger, but they appear to play an outsized role in this case, at least from AT&T's perspective. So I think I wanted to start off by getting your thoughts about the alleged economic benefits in this case. And there seems to be some question about the speculative nature of AT&T's alleged efficiencies, especially around things like targeted advertising. But Mandy, maybe you could start. You've obviously represented clients who've made efficiencies cases in defensive mergers. And my understanding is that in order to count, the efficiencies must be verifiable and merger specific. So what sort of evidence do you think Judge Leon is going to be looking for from AT&T?
So looking at the benefits in this case, so right now, as the prior panel was noting, we're sort of left with the trial briefs. And interestingly, the AT&T brief does include sort of a statement up front that is descriptive in talking about sort of what the projected benefits of the deal are and the synergies. They identify 4. One, as has been noted, was that it's going to create scale in terms of advertising. They will have the ability to drive more targeted advertising. They'll be able to collect customer data and information, and therefore can sort of have this cycle where they generate better ads, which in turn will generate more revenue and take on Google and Facebook. Second, I'm just going to describe these without sort of offering my commentary on them yet. Second, they talk about a variety of form of innovations that they might engage in terms of new bundles, an ability to capitalize on social media. If I'm being pretty superficial here, it's because this is like a paragraph and a half in the brief, so it's really hard to say what they are. But one can imagine a high-tech company having access to more content, being able to come up with perhaps more specialized bundles and the like that they might deliver for free to their AT&T device subscribers, for example. Third, this one was interesting to me just because as a consumer, I guess it's a benefit, but they say they'll be able to have more advertising and better marketing. So now when you walk by an AT&T store, there will be advertising for programming as well. I find myself inundated with advertising, so I'm not sure if that's a benefit, but that's one of the 4 that they articulate. And then the last, which I think is the most specific, most important from an antitrust perspective, is they say there'll be specific cost savings. And then they point to the fact that there will be a virtual cycle in terms of more innovation, will lead to more investment and the like. And this is really where you'd expect to see the action and litigation. So with their brief, that's what you get. It's like 3 pages. I've summarized it. So why are they taking this approach? So usually when you read a trial brief, you sort of go right to the substance, the facts, and you glaze past the standard of review. There's something really interesting going on, which is not surprising, which is both parties have a dueling interpretation of what the standard of review and the legal standard will be that the court will apply. And what's interesting is that AT&T takes the position that in a vertical merger, the burden is on the government, full stop. They have to prove everything. That's what they say. And the government takes the position, looking at Baker Hughes and a variety of prior cases, that there is a bit of a burden-shifting framework, that they have to come forward and prove that the merger is substantially likely to harm competition, that AT&T will have to rebut that, and that the ultimate burden of persuasion is with them. This seems like a small, subtle nuance, but I actually think there could be a lot of activity in the decision with regard to this that could be really important, because what AT&T is arguing is that in a vertical merger, basically there are presumed justifications and benefits, and that the burden doesn't really ever shift back to them. Now, in reality, is that how it's going to work? I'm sort of skeptical just because I think a federal judge is going to have, these two sides of evidence. And the government's going to come forward and say the deal is problematic. And AT&T is going to say, no, it's not, because. And the best offense is, and sometimes the best defense, by saying it's not because they haven't carried the burden, but they're presumably going to want to put forward all of the other evidence of the efficiencies and the benefits. So why does this sort of go back to Katrina's question about how to think about this in terms of are the benefits verifiable and merger specific? I think they're benefits, for the most part, as they allege are. The question is, are they going to have enough proof to demonstrate them, and what is the judge going to do with that? And so if you look at sort of the last horizontal merger cases that have been tried, the benefits and the efficiencies haven't really been a key part of the case. And that's not surprising, because in horizontal cases, they rarely are sufficiently compelling to get the DOJ's attention or the court's attention. But what I think is a little surprising here is I'm a little surprised, and it could be because it's all confidential, or it could be things are moving fast, but I am a little surprised that there hasn't been greater attention played to that side of the story. Because if you begin from the premise that vertical mergers are supposed to be pro-competitive, which is AT&T's theory, you would expect a greater emphasis on that type of evidence. And so now if you're putting this case forward and you want to have merger-specific evidence, you want to have evidence that your variable costs are going to be lower, and that in turn you're going to be able to deliver a lower price to consumers. And they haven't argued that in their briefs. It's a pretrial brief. There's going to be evidence, there's going to be documents, there's going to be data, and there's going to be economists, so maybe this will come out. But so far, there hasn't been a lot of that, and I think the judge will be looking for that, because I think if he decides to allow the merger to go through, he's going to want to write an opinion that's going to explain why, and I don't think it's going to just be the government didn't carry its burden, full stop. I think he's going to want to explain they didn't carry it because they didn't show anti-competitive effects, and there is a story for why this deal is pro-competitive. And so I think the evidence that they've, the theories they put forward do seem to be merger specific, but I'm not sure that they are, verifiable or specific enough. And this is all, pre-trial, so it remains to be seen.
Thank you. And Harold, I know that you have you've studied, you have some thoughts on this, and obviously have studied some of these efficiencies claims, including the targeted advertising. So what are your thoughts?
Yeah, I mean, first of all, it's always funny to me because I'm primarily a telecom lawyer where we do this public interest analysis at the FCC. And I'm told that antitrust is not, concerned with these social policy trade-offs, that this is where, the real analysis takes place and not this touchy-feely stuff that we're all into, at the FCC, except where it helps the applicants. Because suddenly the question is not, well, are you is this, in the words of the statute, may have the effect of substantially lessening competition. There's now an unwritten little codicil that says, but unless it's worth it. And in fact, DOJ in its brief sort of briefly pushes back on and says, there is no efficiencies defense in antitrust. It's just a paragraph. They don't spend a lot of time pushing back on it. But there is, I think, something of a real question here about the nature of these efficiencies and how provable they are. And some of them are, if we were doing a full-throated public interest analysis at the FCC, we would raise some counter-arguments about these just as efficiencies. So the addressable advertising, first we'd note that AT&T is now claiming they will totally do the thing that they said was totally impossible in 2016 when we were having a rulemaking around their ability to use this addressable advertising to boost revenue significantly. But okay, I guess things got better in 2 years. The other question is, it's not clear to me if there is some sort of pro-competitive argument. It's not clear to me how this helps you compete, quote, better against Google and Facebook, because it's a different sort of addressable advertising model. What they're saying is we'll be able to, place advertising on our content that we know people are looking for, but we'll be able to charge advertisers more for the ad on a TNT show, for your rerun of The Big Bang Theory or whatever, because right now you're primarily limited to the standard, this many people watch in this demographic, and therefore I put my ad, associated with this programming. Now I will know that the person who is viewing this online is interested in particular sorts of things. So, drop the beer ad and go with the wine ad or whatever it is. That's, an improvement in terms of profitability, but there's no effort to explain how that somehow lets you compete better with Google and Facebook in the general online marketplace. It doesn't tell me that necessarily more people will come to you rather than them, and there'll be a price war, which would then somehow benefit consumers. It tells me you'll be able to charge more for the product you're delivering now because you'll be able to do it smarter. Okay, that's good, but it's not a competition story. Then there's the argument that is broadly and generally made that any increase in revenue is somehow going to be good and reflected back to the consumer. I find that always very skeptical because Econ 101 tells me that, particularly if it were in fact true, as I would argue that this substantially lessens competition, the incentive to pass the savings back to consumer is lost. And in fact, one of the concerns to me is if you really can, if you agree we can raise the cost of programming, then, and again, I recognize there's going to be arguments about it, that my ability to raise the cost of programming means that I will not have to lower prices to compete with my rivals, which is part of the usual efficiencies argument. Usually a vertical is efficient because it means I'm paying less for an input, so I will pass that savings along to a consumer. Here, I'm paying less for the input, I'm getting the programming, but I'm not promising that I will pass that efficiency along, and in fact, if I'm able to sustain the current price levels or even, raise them, I don't have to pass that efficiency along. So, as I say, I'm highly skeptical about proving the efficiencies, but even if we accepted these efficiencies as true, I don't see where they go to enhance consumer welfare, which is what I'm told is supposed to be the whole reason for mentioning these efficiencies in the first place.
Thank you. Yeah, Peter?
Yeah, in my looking at this stuff when I was at DOJ, I never was really greatly impressed with the efficiencies claims, and these were mostly in horizontal mergers. And I think that the lack of verbiage in the briefs might indicate, you would think it would indicate, that these arguments are not so compelling on behalf of AT&T, that if they really had something more than this is going to help us compete with Google and Facebook, that they would have mentioned it in a more direct and substantial way. So I think that, the first panel sort of focused on all the weaknesses, in terms of being able to show harms by the government in some sense. And I think that on this, in this arena, I think it's really, really hard for AT&T to show that there are going to be these very cognizable merger-specific benefits that will accrue from the merger. The advertising stuff, I don't want to be in the Blade Runner movie where I'm walking by a store and it gives me an advertisement or whatever. I think that that's sort of what AT&T is talking about. And really, that advantage accrues to them, and they don't really talk about it, but it might accrue to them over their wireless networks. It might be a disadvantage that they might be able to impose on the VMVPDs, but I don't see a huge amount of, and I think that's why they have to argue in their brief that the government is not going to meet its burden, full stop. And there isn't going to be a burden shifting to us because they don't have a lot of ammunition to show that they're going to show these efficiencies.
Yeah, and part of what's interesting and to a certain extent troubling to me is there are a bunch of things that they could have argued that they didn't. And that I'm very surprised that they didn't argue and dwell on, which you would have seen more of, I think, if there were an FCC side to this. One is their ability to compete out of region with other MVPDs, not simply as DirecTV, but also through their over-the-top service and address that form of competition, where in theory they're competing with Comcast or Charter already through their DirecTV to the home, but there's an argument that they could have made that, well, that competition has always been hard for us because there are lots of switching costs and the broadband issue, which they'd argue when they acquired DirecTV for why they needed DirecTV, but now we have an over-the-top that will directly compete without any of the usually associated switching cost of moving from a cable MVPD to a satellite MVPD, and that will create good price competition with cable operators. They did not make that argument. They address it to some degree as part of their argument about why we should devalue the potential of picking up customers because cable operators aren't everywhere and in every market, but they're saying we're going to compete, and so I'm surprised they don't mention that. A little troubled they don't mention that. They have one or two references to potentially skinny bundles, which has been another area where competition policy has been significant. They don't dwell on any of that either. There's no commitment or promise to say, hey, you know what, we'll have a streaming package that will be, just TNT, or, we'll be able to do more with the HBO Go as a separate package that you won't need cable for. None of the bait that I would have expected with regard to OTT-based competition or skinnier bundles, which would also then more directly tie back these efficiencies to consumer benefits, and I'm not sure why that is.
So I think one of the challenges on that, and what may come out at trial, is the challenge with these mergers where you're dealing with dynamic industries, and there is huge shift going on in the industry, so you're going from everybody plugging a cord into the wall to walking down the street and streaming March Madness, is projecting how that is all going to look in your ordinary course documents, looking at a 2-year merger horizon, which is sort of the framework we're struck with, doesn't always really work that well. And so from an evidentiary standpoint, and it's not to derail the conversation as like antitrust just not doing its job, but as someone who makes arguments about dynamic change and everybody's like, where's your ordinary course document, Latham and Watkins and big corporation X that shows this is what the world's going to look like and here's what you're going to do with it. It's hard to sometimes prove that, so you're left to rely on an economist to say you have the incentive to do so, and I think there'll be some of that. But what would be helpful to AT&T and what may or may not come out at trial will be documents that show that they do believe they are threatened by Netflix and why they need to do this deal to compete harder with over-the-top and the like. And it's not clear that they necessarily do, because Netflix, started as a company that when I was clerking, I got DVDs from and watched, movies, and that was it. And now we all subscribe and watch House of Cards, and it's totally evolved. And they didn't have to buy a bunch of content to do that. They innovated. And so that to me is the challenge of this. Is I actually think AT&T probably does have lots of things they want to do, and some of them may be merger specific that they could do quicker with the content, but I'm just not sure how, other than a CEO saying this is what they're going to do, and then someone saying, well, you're just saying that for trial, you prove that in a trial, which again I think is why they're going back to sort of first principles with the law and saying the government has the burden, they have to show it's substantially likely to be anti-competitive, and they can't do it.
I think that part of what's going on, and maybe I'm wrong, but I think that AT&T is searching for a strategy. And I'm still kind of scratching my head over why they thought that buying DirecTV was so crucial and essential to their future. And I'm also, I mean, in the context of owning DirecTV, Time Warner makes more sense. But I think we can't underestimate the, they're becoming more and more like Basking Ridge. In other words, they seem to be kind of casting about. We have this idea of corporations as these very efficient, smart and, intelligent entities. And I'm not sure that that's necessarily the case here. I think that they, in today's market, feel a pressure on their stock price to do something. And I think that may be part of the reason why their argument about Facebook and Google is a little incoherent. I do think, and this is something that I don't think the government's brief addressed adequately, I do think that there is an impact on the content markets of Amazon and Netflix rising up and providing other opportunities for people who want to get distribution of video content. But I don't think that they necessarily have this whole strategy together. I think they kind of did this without, thinking about it for years and deciding this is the strategy we have to strike on.
Do you agree with that, Harold?
Well, yeah, I mean, I do think that one of the things is that the DirecTV deal was, in many ways, a defensive deal back when the Comcast Time Warner Cable deal was announced. And then everybody was sort of scrambling around looking for partners because scale was going to be so vitally important. And AT&T announced its deal with DirecTV, and then Comcast Time Warner Cable didn't happen, but they ended up with DirecTV. So then they're like, okay, how are we going to leverage this? Well, let's do what Comcast did and get the content. So I do think that there is some executions and changes in strategy. I also think, based to some degree on conversations I've had with folks in the industry, that, everybody had pretty much accepted a world where there was going to be some form of net neutrality, and now that is no longer taken as a certainty. And so, that's a whole new realm of vistas of possibility, and a new set of threats become open up, and I think that AT&T has responded to some degree with, well, let's stockpile content, so whatever happens will happen. So yeah, I think there's some flailing around on that in terms of strategy, as well as also I think that there is also truth to the matter that in a dynamic industry, it is hard to predict precisely what you're going to do. That AT&T says, well, if we have this content, we could potentially do this, this, and this. We'll have to see what what looks like the good thing to do with it. Which I do think is different, in many ways than Comcast and what they did with NBCU, where they very clearly wanted to acquire a major content network for some time, and then when the opportunity arose, they took advantage of that.
I think, so you've all mentioned the dynamic industry, and Mandy, I think, made a good point when she was talking about the lack of ordinary course documents in that context, but I think where we do see a lot of ordinary course documents and also testimony in DOJ's brief related to comments that DirecTV and AT&T made to the FCC in other contexts. For DirecTV, it was in the context of the NBCU deal, talking about how vertically integrated programmers have the ability and incentive to hinder competition. So I guess I'm just wondering what all your thoughts are on how damaging these are to AT&T's case. Mandy, maybe we can start with you.
So the thing that's interesting about the ordinary course documents that are getting highlighted in this case are that they actually aren't from this case, right? I actually think that's, when you look at the complaints from the recent horizontal mergers, it's the CEO from the company that's acquiring the other company saying, we're going to buy these guys to kill competition, and it's a nightmare. It's a nightmare for the company, it's a jackpot for the DOJ, it's a nightmare for the lawyers. What I found really interesting and surprising when the complaint came out is that it references ordinary course documents, but they did a full investigation. They had documents, and they didn't cite bad documents related to this deal. So they had to go back to their, treasure trove and pull out something from another deal.
They cited some.
No, they cited some, but they weren't of the magnitude and the color that they've cited in others.
Right.
And they've, the DOJ has gotten very good at, taking documents and using them, against the merging parties. And you could say the parties have gotten better about not creating them. I'm sure there's some of that too. But when you're emailing a year before the deal, right, and you're talking about things that you could do or would do, that can create fodder. And so I think it's interesting that there is a lack of that. Now, the documents from before, Steve made the point that basically we're in a content arms race, right? So it's a content Cold War. Everybody's got to acquire their content so that they can be on the defensive position, so that they won't have to have someone deny them content, because they'll be able to say, I have Warner Brothers, I have Turner, you have Disney, you have ESPN, you have NBC, you have this, that, and the other. And so we are getting into an environment that feels like that. So I don't know that those documents are as damaging as they appear, because if one of the justifications for the deal is they need content to continue to compete, to me you can kind of spin that around and say, the government allowed this deal to clear, this judge signed off on that consent order, and our reason for doing this deal is the model is changing. We need to be fully integrated to be efficient. And so we challenged that because we thought that was bad, but that's the world we've gone to 7 years later. So they're not, would it be easier for AT&T if they didn't exist? Of course, but do I think they're, fatal? No, I think you can totally turn them around and describe them in the context of the deal. I will be very interested to see if there are more documents about this deal that can come back to haunt the parties. And I tend to think it's a vertical deal, and it's really going to come down to the economics more so than these horizontal deals where it's just been about the color from the documents.
Well,
Those kind of intent documents are helpful. They're more sort of, in my mind, helpful in terms of shaping the public thinking about a deal. Listen, when I was looking at Microsoft stuff, they were destroying everybody every day, and it was, but did a judge really feel that stuff was terribly probative? Certainly in those horizontal kinds of contexts, not so much.
I disagree with that, but I'll let you keep going.
Okay. I was always wary of...
You're very responsible.
Yes, I was a former government employee. I was very wary of DOJ having to rely on that kind of stuff, that we needed more sort of substantive in the sense that this is the way the mechanism is going to work, as opposed to we would really like to do X. The other thing that I have to say, somewhat apropos of this point, is that, and maybe I'm wrong, maybe I haven't looked at that many briefs, but I don't remember a brief being redacted so much as this one. And it is interesting, as you say, that it seems like all the big arrows in the quiver are from 7 years ago. And it may be that there were other documents that they thought were good, but they deposed them on them and they were able to effectively walk away, which is part of the reason that I was always kind of skeptical of those kinds of things as being terribly probative, because a middle manager can say, this is going to be the way that it's going to work, and that can be walked back by people above him or her in so many ways. They can't walk back the statements that they made to the FCC because those were company policy. But it is interesting to think that in the context of NBCU, the Justice Department decided that it didn't think that there were any crucial antitrust issues that had to be put into the decree other than the control of Hulu. Now, staff might have thought different things about that, but I think that, and so people talk about, are they going to extend the decree or whatever, and that just doesn't make any sense because it's just about Hulu.
I think you're looking at these documents wrong, or rather, I think you're not looking at these documents as DOJ will play them. Which, and I also want to touch the Comcast NBCU point, because it's one of these things that comes up there, and we have a little tea leaf from a footnote in Judge Leon's previous order that may be relevant. But first, on the nature of the documents, it's not, the way I would expect to see DOJ frame this is not that the documents prove our theoretical work. It's more that the documents undermine AT&T's theoretical work, which is to say, you, AT&T, are coming in with a case in which your expert is showing it is impossible. Nobody could imagine in the world that anyone would do this. Competitors will laugh in our faces if we try to, accept that you have lots of statements that your entire policy is driven by, that it is possible, that competitors will take this threat very seriously, and that it is not simply from the, your own opinion, but also from Dish and other competitors, where they also take this very seriously, which brings us to, what the theory empirical problem in any of these. We're trying to predict the future. So what's going to prove? You've got dueling theories. How do I know which theory is right? Well, one potential indicator is, what does everybody in the industry believe? And if I can show that, you got dueling experts, but pretty much everybody in the industry, when they're not in a trial situation, agrees with the Department of Justice's experts, then if I'm a judge, I'm more like, yeah, okay, if everybody believes, this story to the point where their entire business strategy is shaped around the ability to withhold and raise price story, then maybe I ought to believe their expert rather than the expert who says that it's impossible. So I think there is that element. I think that the argument about Comcast is a very interesting one, because, of course, Judge Leon actually was very suspicious initially of okaying the Comcast decree. He actually pushed back and said, well, if this stuff is as bad as you say it is in the complaint, why should we do a consent decree? So it is somewhat easier, I think, for the Department of Justice to come in with a little hangdog expression and say, you were so right, Judge. Gosh, we were so dumb. You were so right. I wish we'd listened to you then, but we're totally listening to you now. Now, Judge Leon, for his part, dropped this little footnote in the order denying AT&T's discovery request, in which he said, the parties invite me to compare this to Comcast NBCU. Well, I'm not going to do that. You're going to, at trial, show on the evidence whether this is a good merger or not. And I think that, from what we have seen so far, which is very little, that there is a pushback on this idea, either that one, on the side that I would agree with on the DOJ side, that Comcast NBCU shows that behavioral remedies in this instance don't work. There are too many ways around them. They did all this stuff anyway. We don't want to repeat that mistake, and it's overly burdensome. But also goes to it runs counter to that somehow a consent decree is a precedent that binds either DOJ in how they must treat a merger, or which binds the court in how it should consider the proposed remedy. And I think that to the extent that we have any signal on that Judge Leon has sent a signal and says, I want to talk about Comcast NBCU here. I'm going to do the deal that's in front of me on the basis of the law that's in front of me.
Mandy, Peter, do either of you have comments on, or I guess a response to Harold's points?
I guess I have one observation while we're just sort of doing our Comcast NBC detour, which is going back to the prior panel, in this idea of the fix it first. So what AT&T is trying to argue is that on the merits, if you consider their proposal, on the merits, the transaction is not substantially likely to lead to a decrease in competition. The challenge is that they didn't have a consent order because they couldn't get one, so they're stuck offering the private commitment. the problem, I think, that for the judge is going to be, as much as he didn't like the consent order, the one place where I do think NBC Comcast might creep into his mind is this just general idea that there is a big difference between private contracts and being under a government order. And as someone who's done both, I can tell you being under a government order is, a much bigger, significant, difficult, endeavor. And so I would expect that the DOJ will push back and say, they've made their private commitment, but, they could try and terminate that, and then we'll be in breach of contract, negotiation related to the arbitration clause. They could try and get out of it. And then the other challenge with what they've done is they've made the 7-year commitment, which is, basically what Comcast NBC did. And so just temporally, the interesting thing that has happened is we're basically coming up to the end of NBC Comcast. In 7 years, in antitrust in a dynamic market is a long time, and you do expect big change. But there is this sort of interesting element, which is that one's coming up to be, expire. And there could be discussion about whether you renew it and continue to put them under order, although I think Peter makes a very good point about the scope of it being related to Hulu. But 7 years later, how much have things changed? And so it is this 7-year commitment. I don't know that the judge will find that in the context of 7 years has kind of flown by, and here we are, to be that compelling. But I think the fact that it's not under order, which is, it's the best they can do under the circumstances, I'm not sure that from a litigating the fixed standpoint, it's behavioral, it's not structural, and there's no real certainty that it's going to work. And so I think that will be one of the issues that Judge Leon's going to struggle with.
I do agree with what Harold said in terms of the judge's feeling about the case, that he has to decide the controversy that's in front of him. I think he's a small C conservative in that sense, and that he's going to stick to his knitting and to use a mixed metaphor, to decide this case and not relitigate what DOJ might have done. Those of us who sort of talk about this, in this forum and others, we're sort of trapped in this notion of trying to be logical about it. So that's sort of kind of a pitfall that AT&T should not fall into. That they really have to focus here on convincing the judge that A, it's not going to lessen competition, and that B, that the market has changed. And I don't think they did a great job in their brief sort of explicating what are the pressures that Amazon and Netflix and the like are putting on them, and how does that impact. Also, I don't think, actually Hal pointed this out in the previous panel, the market power that DirecTV has is so different than what Comcast has because they don't have the internet. And so I don't think they really pushed on that. AT&T didn't push on that in their brief, that they really have their ability to make mischief is far greater. But I think it's because of that weakness in DirecTV that they felt they needed to sort of scale up and whatever. The other thing that occurs to me, just sort of apropos of nothing, is that it doesn't seem like either party, and we'll see what the evidence shows, has accumulated a real analysis of the pricing that's happened over the last several years in the wake of the NBCU Comcast. And the way that might be relevant is that is sort of a natural experiment. You had this vertically integrated firm. What market power were they able to exercise? And in that whole time, the other thing that seems to be lost in the conversation here is the fact that this market is bleeding subscribers. I think it's like 22 million over the last 7 years or something like that. I mean, it used to be sort of a article of faith that when we were doing these analyses at DOJ and FCC, that sort of the ballpark number was 100 million households, and 95 million of them were MVPD subscribers. That's not the case anymore. The ability to raise prices as an MVPD is constrained by cord cutting and cord shaving. And I'm not exactly sure how that fits into this analysis, but it seems to be a pretty important fact that is not being accounted for in the briefs.
Well, I mean, I don't want to wander too far afield, but I will point out that if there's a price constraint, it hasn't been seen by consumers, because prices keep going up, which is one of the oddest things about this market. In a market that is supposedly hemorrhaging customers, we continue to see prices rise, both the direct price of video subscription and indirectly through below-line fees such as cable box subscriber fees and so forth. And what we're also seeing, which I will leave to future antitrust panels, is now, as cord cutting goes on, an increase in the overall price of broadband by MVPDs who are also providers. Now, these markets are, if I wanted to set as an academic exercise, again, I'm not an economist, but there are a lot of interesting questions that I might ask about how the market behavior is working, particularly when we start to break down the fact is that cord cutters are cord never wers, which is, part of the debate. Are we simply talking about a new generation of consumers that over time, as they undergo household formation, are not subscribing in the way that previous ones did? Are costs being driven by somebody else so that we've passed the market? Market theory tells us that if you raise price too high, you lose customers. Is it that sports programming has gotten so expensive that cable operators have no choice but to raise price past where they otherwise would in order to be profitable? I mean, there are a lot of things that could be going on, which we will see argued in the question of what is the market, as to whether Netflix and Amazon and these other OTT video on demand type services are part of that same market or not for purposes of the analysis, which I will say it's an interesting question. Having been in this area for a long time, to when I can remember that supposedly DVDs were competitors to cable, and the dial-up internet was supposed to be a competitor to cable. I recognize that there's an argument that has been made for a very long time around this that was ridiculous 20 years ago and was potentially plausible and may someday be right, but it's not clear to me where we are in all of that. But then that brings in the second question, which DOJ alludes to, which is okay, let's assume that these are competitors. Do I have greater incentive to deprive that class of competitors from the programming, to staunch the bleeding and keep the online streaming crowd to my OTT, rather than have them drop not just DirecTV as a MVPD, but not also subscribe to DirecTV as as an OTT, whereas Time Warner, presumably on its own, would, if it could get similar affiliate fees from Netflix for a streaming service as it did from MVPDs, would be more willing to offer up that type of programming. So complicated questions that I don't think you can easily say weigh definitively in one direction or the other direction.
So Harold, I think, brings up some interesting questions about product market definition, and I'd like to come back to that if we have some time. But I know, first of all, Mandy has a hard stop at 11.
I just emailed, said I'm running late, so.
Oh, perfect. But I'd also like to leave some time for the audience to ask some questions, so maybe we'll do that now, if anybody has questions.
I have a quick question. How worried should Comcast be that they'll get investigated next for owning NBC? If that's the logical conclusion of DOJ's problem with behavioral remedies.
Yeah, it's an interesting issue. I don't think that Comcast would have gotten the consent decree from Del Rahim that they got in the Obama administration. Whether he would at that point have seen the same danger to competition, I'm not sure, but certainly, it strikes me as pretty consistent with what he's said traditionally about, being conservative antitrust means we don't want to turn this into regulation. We want to just, it's either good or it's not good. Or you solve it with a divestiture or you don't solve it at all. So saying that, I do think that while in theory the standards are supposed to be similar for an investigation as for a, in terms of what you have to prove the trial and who is the burden of proof, the reality is that one of the reasons why we did the Hart-Scott-Rodino Act was it's easier in practice to stop at a merger than it is to do an investigation and then have another decree. So I think certainly Comcast ought to be worried that if the government wins, I think that worried not just for the possibility of investigation, but also because it would mean that they're out of the running for any of the News Corp assets. Conversely, if AT&T wins, Comcast should be enormously happy, particularly because they will now have a much broader expanded scope as to potential acquisition targets in the content space.
So the challenge is antitrust law goes after conduct, not prices. So they would have to do something that would warrant an investigation. Maybe there's something now that you can point to as anti-competitive conduct with the bundling. I don't know. I don't see a clear theory, but there would have to be some discernible conduct. But I think the interesting issue for Comcast and for the DOJ is that if the DOJ were to win this case, they would feel very empowered to want to do something with Comcast, and the logical thing to do would be to extend the consent order, except they've said they're not going to do behavioral remedies. So I guess the consent order expires unless they're going to, try and go after the merger 7 years later. I mean, I just don't see that happening. Who knows? But that's the challenge, is you have to have conduct. So they'd either have to do an acquisition or be engaged in something under the Sherman Act that's problematic. So right now, they're relative to, unless they want to do other deals, which, that's a separate question, they're kind of in a good place.
Peter, did you have?
I don't disagree with Mandy. I think that certainly there's been a political veneer to this, in that Republican administrations that I experienced were extremely reluctant to do any sort of conduct investigation. But this is a different day. If the government wins this trial, then they might think, well, yeah, let's put Comcast under increased scrutiny. But like Mandy said, they have to have done something, predatory pricing or withholding, inputs from competitors, that kind of thing, that is really specific, as opposed to, we think the merger is going to do this. Even though the standards aren't that different, they're a bit more expansive under the merger laws under Section 7 of the Clayton Act than they are under monopolization under the Sherman Act. So I think that I wouldn't worry too much if I were Comcast. I think the bigger impact is on their ability to make acquisitions like Fox.
Yep. Other questions?
Charles, I wanted to ask you, you made mention of the fact that AT&T said it was impossible to get additional advertising revenue or to address advertising in 2016. I wasn't familiar with what that was, but I wondered if, their point with this deal, I think, is that when they have a lot of data, and Time Warner has a lot of content, but doesn't have any data about who's getting that content. And so when you marry the two, then you can get a lot more advertising revenue. Forget about competing with Google and Facebook, but they'll just say the way that Google and Facebook do, because they know who's looking at what, and therefore they can target things to those people. So I'm just curious if when they said in 2016 that they couldn't get more advertising revenue, was that as a status quo company, or was that if they had bought a bunch of content?
It was more of the issue of how sophisticated the addressability was going to be. And I exaggerate slightly when I say they didn't claim that they could get more revenue. What they were actually saying is that our ability to monitor consumer activity and track beyond traditional behavioral advertising of what you're watching in terms of activity from screen to screen, is limited, especially when compared to Google and other online platforms. The argument that they're making now, and that really they've advertised about for a very long time, is that in fact it is as sophisticated as the folks at Public Knowledge and CDT were saying it was, and therefore our ability to monetize it is fairly high. Again, what struck me as what struck me as stunning about this was that this was claimed as a merger efficiency, and as a positive reason to allow the merger to proceed. And it seemed to me that if we were going to bring that in, that in fact we ought to be talking about the privacy concerns. If the European Union now considers issues around privacy and stockpiling data to be part of its antitrust review, we don't do that here in the United States. But if you're going to try to flip this on me as being an efficiency for which I should give you credit, then we also should consider the potential harm.
So we've hit the 50-minute mark. I think unless there is one more quick question, otherwise I think we are going to bring this panel to a close. But want to thank you all for participating.